everyone, and welcome to this webinar on cross-examination in international arbitration, jointly organized by Young ISTAC and Young ISTAC. My name is Alina Papanastasiou, and I am an events coordinator for Young ISTAC. I will be moderating today's webinar along with Leila Orak Telikpoya, who is a Young ISTAC representative, and who will also make some concluding remarks at the end of the webinar. Now, before we begin, I will just say a few words on Young ISTAC, which was established in 2010 with a mission to open the doors of international arbitration. We have just celebrated the organization's 10 years anniversary, and we think we're well on our way to fulfilling our goals. We now have over 8,500 participants, members around the world, benefiting from the program we offer. And these programs include workshops and webinars like this one, focused on the development of practical skills relevant to the practice of international arbitration for early career professionals mostly, students and young lawyers. Full tuition scholarships for graduate degree in dispute resolution at the universities in the United States, Switzerland, and China. A blog platform on which we publish a curated selection of contributions from members of Young ISTAC on timely issues in international arbitration. And finally, a mentorship program through which we pair participants with senior practitioners for a 2-year cycle in which they receive ongoing advising and career guidance. Of course, if you're interested in finding more about Young ISTAC, feel free to visit his website and check its upcoming events and activities. With that being said, it is time to move on to the gist of this webinar, which will be structured as follows. First, we will have an around 30-minute panel session during which we will hear from our distinguished speakers today. And we are very happy to have here with us Mr. Yalin Akmenek, partner at Ezin Attorney Partnership, member of Baker McKenzie International, working in Istanbul. Ms. Jada Tengiza, consultant at Altamind in Paris. Professor Janet Walker, independent chartered arbitrator based in Toronto, and Ms. Angeline Wells, barrister at Essex Court Chambers in London. Of course, you can find more details about our speakers' broad experience and activities at this webinar's registration page. We are very lucky to have them all with us today, and we're looking forward to hearing the tips and insights that they will share with us from their broad experience. After the panel session, we'll move on to a mock cross-examination session held based on a case which has been already distributed to you upon registration. And this will then be followed by a Q&A session, mostly based on live questions you can submit during this webinar. And Leila will then close the event with a few concluding remarks. We're very happy to have already received a lot of questions from registrants, and we will do our best to share them with our speakers during this webinar. But if there are any other questions you'd like to ask, please feel free to type them into the Q&A panel of the Zoom meeting at the bottom of your screen, and we'll try to get to as many as possible. Finally, please remember that this webinar is being recorded and will be made available on Young ISTAC's website within a few weeks after the webinar. So without further ado, I'm going to lead us off with a general topic of preparing for cross-examination. And I will give the floor to Ms. Angeline Wells to give us the first practical tips on the stage of preparing for a cross-examination in international arbitration. Angeline, the floor is yours.
Thank you very much. Thank you very much to the organisers for inviting me to be part of the panel today. I'm delighted to be speaking to you no matter where you are in the world. So I've been asked to start off by answering the question, how should one prepare for cross-examination? What are the do's and don'ts and practical tips? So I thought that, I mean, there's obviously quite a lot that could be said about this, but I wanted to give you my tips as briefly as I can. So I had, before I get into some of the practical organisational points, I had about 4 points in relation to the theory for preparing your cross-examination. So I would say the first point is the most important thing is before you even sit down and start working out what questions you're going to ask, you need to work out what it is that you want to get from cross-examination for the case as a whole. You always need to plan in advance where do you want to be at the end of the hearing. And so what do you want to get out of cross-examination? Obviously, you have to ask yourself the question, what is the evidence that you need to support your case? And what is the evidence you require to defend the case which is being made against you? You've all had the case study that we're going to be looking at today. So if we take our case study by way of example, and we assume that we're acting for the respondent, then we need to first of all work out whether find additional evidence that Mr. Robart retained and used confidential information to set up a new business, which is a breaches of confidentiality in the SPA we allege. And secondly, defend the claim that the buyer did not cooperate to reach the business development goals set out in Article 5 of the SPA. In other words, try and justify also the decision why we terminated the contract with Mr. Robot or otherwise acted unreasonably. So that is what we're looking for. The second point to make about this is we're looking for evidence that the witness will be able to give which goes beyond what is already there in the written record. Because obviously, if it's already there in the written record, unless it's been challenged or there's a point of dispute, which you need to clarify, that's one purpose of cross-examination. But typically what you're trying to see is, well, what more can I get by way of oral evidence? And I mention that because one of the things that you have to strike a balance when you're cross-examination or putting your questions together is you have to quite often route your questions by reference to documents. But what you don't want to do, and what is sometimes done, is cross-examination is essentially used as a mechanism to take the tribunal through the documents by getting witnesses to comment on them. Occasionally there may be some merit in this to route your questions in some way, give them foundation, but typically that's not what we're trying to do with cross-examination. We're looking for something more beyond the existing evidential record. The third point that I wanted to make is you should always know when you're preparing your questions what the answer is, or you should not care about what the answer that's going to be given is. Or third, you should have backup from other documents or other evidence to contradict whatever the witness tells you. In other words, when you're cross-examining, you always want to be in control of the process. And if you start asking open questions, which gives the witness an opportunity to say whatever they like or make their case, that's going to be unhelpful because that's expanding the evidence against you, not getting useful evidence out of it. And the way in which to control the witness is to be able to always, if they say something you don't necessarily expect, you can at least go back to them with something which shows to the contrary, and then you can show that to the tribunal too. The fourth point I wanted to make on theory is you need to think very carefully about what are the propositions that you're putting to the witness, because cross-examination is essentially that, putting a series of propositions to a witness. And whether that witness is likely to accept them, whether that witness is the right witness to accept them, whether you want to ask a different witness to get the proposition that you want. And also think strategically about the structure of your cross-examination. If you signal too strongly early on where you're going with your questions, then the more likely it is that the witness will try to argue his or her case when they're giving evidence and reply, which is not what you want either. So very quickly, practical organisation points. The first point I want to say is a cross-examination script is essential. People have different ways of doing that. I typically write my questions all out. You could just put bullet points for the proposition you want and phrase the question as you go. You should always note in your script where you're taking the witness to a document. And so you also know, are you taking them to the document before you ask the question, or asking the question before you go to the document? I tend in my script to note what the possible answers to my questions would be, and then what a possible response will be. If you think about it, it's almost like a decision tree, which you see sometimes expressed. If they say yes, well, you know you can move on. If yes is the answer you want. If they say no, then you might need to challenge them on that. And so you may want to draft in some supplemental questions in order to take that on. I also use subheadings in my cross-examination script. It's important when you're cross-examining someone to make sure everyone in the room knows exactly where your cross-examination is going. And more often than not, it's important that the tribunal understands what you're doing with your cross-examination, because it's too easy, I think, sometimes to forget that people who ultimately benefit for the cross-examination is the tribunal. Now, whatever you get in script, you probably bring to the tribunal's attention and post closing submissions. So it may be the tribunal doesn't work out when you're cross-examining the significance of the point that you've got until closing, but you probably want to give a subheading just so that everybody knows where they are. So let's talk about your background, let's talk about the agreement, then you go into a series of questions. And when you're doing your script, you would organise them in that way. So you know, this is the topic I'm cross-examining on now, and then I'm going to move to a different topic. Finally, on practicalities of organisation bundles, there is a question quite often, well, there are various different ways in which you can organise a hearing bundle these days. We are moving towards electronic bundles, and you're going to see a demonstration in a virtual format. Typically in a virtual format, the document will be brought up on screen so everyone can see it. The witness probably will be looking at it on screen. So we're increasingly moving to that way of organising bundles. If you do have a hard copy set of bundles, it's sometimes the case that counsel who are cross-examining will put together their own cross-examination bundle for that particular witness. It's not any new documents, it's the documents within the proceedings. It's just that they're organised by reference to the cross-examination questions normally, and they're given to the witness as they sit down to do their cross-examination with a copy to the other side. And the reason for doing it more often than not is in big cases, the hearing bundles can be voluminous, there can be many of them, and so you want to speed up the process as quick as you can. You can put them all in one place so you don't lose time trying to find them. So that's what I was going to say about tips, do's and don'ts. Obviously happy to answer any questions when we come to it.
Thank you very much, Angeline. Now I'll give the floor to Janet to continue commenting on the issue on preparation for cross-examination, and specifically the role of junior lawyers in the process.
Absolutely. And there will be only a few brief comments to add. Angeline has set out in wonderful detail the very complex process of preparation. So when all of you see that brilliant cross-examination unfolding and you think that the person is absolutely a wonderful performer, indeed, that's a result almost inevitably of many, many, many hours of very hard work, of thinking highly strategically about exactly what you need to get on the transcript from this witness, and how you're going to do that, the many possible answers that that witness might give to a particular question, how you're going to get from that witness the answer that you want, and so on and so forth. That is a huge task, very time consuming, but highly worthwhile. So you can imagine, in managing effectively the time of a good team, you will necessarily want to give those kinds of tasks, to the extent that you can, to younger lawyers on the team. Now, there's a challenge with all of that, and that is there is enormous potential, and it's not infrequently the case that as an arbitrator you see this, for a bit of a disconnect between the preparation and the delivery. And it comes in two ways. On the one hand, if you are preparing a cross-examination that you know you're never going to get a chance to deliver, you do what you think, but you don't work on it quite as hard as if you know that you're going to have to stand and deliver. That's just human nature. But by the same token, if you are going to deliver it and you have not prepared it, there may be all kinds of pitfalls, perils, but also little gems in that cross-examination that you will have missed or you could risk missing. So if you are given the task as a young arbitrator of preparing the cross-examination of a particular witness, to the extent that you have the opportunity, and you should try and make that opportunity, you sit down and you walk through that cross-examination in minute detail with the person who's actually going to do it. But having said that, there's actually far more to it than this, and that is that as a senior counsel, so I'm aware that there may not be many on this call, you should actually give the job of that cross-examination to the person preparing it. And I can say, almost without fail, that I've been enormously impressed by the times when the first chairperson has passed on to another member of the team the task of focusing in on this particular witness, because you can be very confident that that person, being given a chance to shine, will have done everything possible to make that cross-examination a success, and will make sure that it is a success. And I can tell you also, from the perspective of an arbitrator, young or old, to see a fresh face focusing on the cross-examination of a particular witness sort of calls you to attention again, and you focus in that much more closely than you would do if the same person was just conducting every single cross-examination in series. So it can be a very highly valuable opportunity, and if anyone needs to convey this message to one of their senior counsel members of the team, by all means, you can use my name. Please do. So that's what I wish to say about it.
Thank you very much, Janet. I'll make sure to do so. And now I'll give the floor to Jada to discuss a bit more about it and possible ethical considerations that come into play when preparing for cross-examination.
First of all, very happy to be here, and about how to prepare witnesses and what ethical considerations come into play. These questions are actually very much related, because you need to know what rules you operate under and what your professional obligations are to know how and to what extent you can actually prepare your witness, and what constitutes permissible witness preparation, actually. So you should know whether you are allowed and should, under your applicable rules, coach your witness, or whether you should just limit yourself to familiarize the witness with the arbitration, which is something I'll get a bit more into detail later. But it's important to note that when you get into coaching, it's actually a detailed review of the specific facts of the disputes in anticipation of the potential questions that may arise during cross-examination. So it's completely different than just familiarizing the witness with the arbitration and how things are going to go. And without getting into too much detail as to how different jurisdictions consider this question, I will just quickly remind you of the fact that those can be very different. It already comes from a very different tradition between common law and civil law. For example, in civil law in countries like France, cross-examination is not usually and extensively practiced, whereas in common law countries it is a bit more. But even beyond that, when you look at, for example, the fact that English practitioners are extremely limited in their ability to prepare a witness, but on the other hand, US counterparts have a completely different approach, and not preparing a witness and not going to a sort of mock trial would actually be considered as borderline malpractice. So what we get from that is that there's a huge difference in how different jurisdictions approach this matter. And when it comes to arbitration, it can be a big problem, because if the lawyers come from different backgrounds, as it is often the case, the tribunal will be confronted with two different teams of witnesses, ones that were heavily coached and ones that just knows the basics. And if you look into institutional arbitration rules, they're not extremely helpful, because either they're silent on the subject or they're very vague. Like, for example, the ICCA rules will talk about witness interviewing, but that is just a very vague subject and doesn't get into the details. It's the same with the Singapore International Arbitration Center, the SIAC rules. But on the other hand, you have the Stockholm Chamber of Commerce, the ICC, that have no wording about witness preparation. The IBA rules is a bit more detailed. The rules on taking of evidence will talk about discussions with the witness for the prospective testimony. And the IBA guidelines on party representation will go a bit more into the details in Guideline 24 to talk about the discussion and preparation of the testimony. But that's the extent of it. So this is something that needs to be taken into consideration, the fact that there is a clear lack of supranational code of ethics when it comes to arbitration, and that lawyers will usually play by different rules, and it will create an imbalance. Usually arbitrators are very well aware of this, but you can always seek directions from the tribunal and just put the matter out there. And in any event, I think everyone will agree with the fact that tribunals usually appreciate authentic witnesses, so they will not appreciate witnesses that are overly prepared and coached. But it is still an issue that can be raised with the tribunal because of the differences that can come into play. Regardless of those rules, just a few things that I think are important when it comes to preparing the witness. Like I just mentioned, there's a school that coaches the witness, and there is the familiarizing the witness with the arbitration process, which is the basic and something that I think every lawyer has to do. And it comes with explaining the layout of the hearing room, explaining the order of the events, how things are going to go, explaining that while they're being cross-examined, they should look to the tribunal, they should not try to communicate with you. These are basic things that are very important to control the anxiety of the witness. That's one. There's also the fact that you need to refresh the witness's mind. In big cases, sometimes the witnesses have drafted their witness statements years ago. Make sure that they reread their statement, all the documents and exhibits that are relevant to their testimony, other witness statements that can be relevant. All of this will help the witness testify truthfully, like they should be doing. Otherwise, I think it's good to give the witnesses general guidelines, like the fact that they should be telling the truth, obviously. If the proceedings are confidential, as they usually are in arbitration, the witnesses have to be reminded that they should keep everything that is going on during the hearings confidential, that they should listen carefully and take the time to answer before just going into it and trying to quickly wanting to make their points. Not to answer if they don't understand the question. Always ask to document and not answer if there's like a reference to a document. They shouldn't just answer before actually looking at the document. And also explain to them that there could be interpreters and that this is something they should take into consideration when they're testifying. So these are pretty much the things that I wanted to talk about with witness preparation and the ethical rules that come into play.
Thank you very much, Jada. Yalin, do you have anything to add?
Very shortly, thank you, Alina. Very shortly, I think everything has been explained in a perfectly concise way, but I just want to contribute with a couple of examples from some of the things we had, thinking that it may be fruitful. And without any specific order of the topics, there are, I think, 3 short examples I want to share. One of them is when you are preparing yourself for the witness preparation, witness examination, and so don't aim to defeat the other party, or don't be in like we're going into a warlike mode and so. For instance, I have seen witness examinations, crosses, and so very aggressive examinations where the lawyers were shouting to the witnesses. I have even seen one instance where a counsel was shouting at the witness and then said, "Shame on you, how can you do such a thing?" And even those kinds of emotional things and so. And like when you look at the client is very proud because the client feels like my lawyer is being very aggressive. Look, my lawyer has said shame on you to the witness. But most of those witness examinations ended up being unfruitful, with the lawyers trying to do things in an aggressive but uncontrolled way. And the more fruitful examinations that I experienced were always the ones that were done in a calm, planned, and coordinated way. Because, as discussed, what's important is it doesn't matter. It's not that important that you were very aggressive with the witness, or you said shame on you to the witness, or something like that. But to the contrary, what you end up getting in the transcript is very important. So I would say that this is a cultural thing, and especially, for instance, in Turkey, many of the Turkish counsels do have a tendency to almost attack to the witness in a very aggressive way and to try to look the witness bad and so, but it just doesn't work that way in international arbitration. And I think trying to get what you want in a calm way is what matters. That's one thing I want to give as an example. The other thing is with respect to the preparation of witnesses and the way the witnesses should be giving their testimonies is, I think, honesty and accuracy should always be the principle, because in a couple of arbitrations I have seen instances like the chairmans interfered and said to the witnesses or the experts things like, you are here to act as a witness and not as a counsel. You're here to act as a witness and not as an advocate of the other party. And believe me, when somebody says, a witness reaches to a level of advocating things for his side in a very clear way, it really doesn't look good to the tribunal. And for instance, in all those cases where I saw where even the tribunal ended up warning the other party for having advocated on behalf of the party that nominated, things did not work good for those parties. So that's the other thing I would like to add. And the two other short things I want to add is in the preparations, mastering everything, all documents, all information is extremely important. But as discussed, sometimes, unfortunately, the real counsels that have done actual work that know the case very well, and the lead counsel that does the examination do not always end up being the same person. And I have seen instances where the lead counsels ended up missing very much of the important points because they were very good examiners, but they missed factual background, and therefore they ended up, because of their lack of factual information, they ended up missing questions. So that's mastering everything is very important for that purpose. And my last point on this is be prepared for surprises, because usually, especially if you're dealing with an aggressive witness, usually surprises do happen during those examinations and so, and it's important to keep calm and to go on in a coordinated way, even if you end up seeing surprises. These are some personal examples that I would like to share with the participants, and I think everything else has been compiled in a very brief way.
Thank you very much, Galeen. I will now invite all speakers to contribute on tips on successful cross-examination during the actual hearing. So, Janet?
Just three very small points. One actually a very general theoretical point, and that is that if you love advocacy, you will be perfecting the art of cross-examination for your entire career. There is always room for improvement, and the most experienced arbitration practitioners will say to you, they'll still be evaluating this last one. Oh, I could have done this, or that went well, and they will always be thinking, always be improving their technique. So do not worry that there is someone further along the path who looks good and you do not. There is always room for improvement. The second one is in the actual hearing, in connection with that, one of the most, I think, important things is for you to take your time. You've prepared very well. You've got the question just down pat. Take your time to ask it. Watch the witness. Make sure the witness has heard your question and understands the question. And then let the witness answer. You worked hard. You know what the possible opportunities are. Let them answer. Let them finish what they have to say. And then you can speak. Now, it may well be that you've got a very difficult witness and you have to say to them, no, Ms. Terminator, you have not answered my question. Let me repeat it for you so that you can think about it. Or, Ms. Terminator, I did not ask you about that. Let me repeat my question for you so that you can answer it. And if this goes on repeatedly and the witness is non-responsive, you can count on the fact that that what you get is what you get, and you'll have to move on from that, or the tribunal will say, we can see that you're not going to get the answer to the question that you've asked, and then you will be able to move on. And you will have to sort of think about when that is that you move on. But to take your time and listen very closely to the answer, know when you've got what you want. What actually counts in all of this is the words on the transcript at the end of the day. If you've paused to listen to an answer and then decided you're going to move on, that may be 20 seconds, 30 seconds of silence. If you're nervous, that will seem like 2 hours and you'll rush through that whole process. But what you should know is that 20 seconds of silence doesn't look like anything on the transcript. Getting the right answer does matter. So that's the second point. And the last point is just to do with the bundle. And that is, Angelina is absolutely right. Whether it's hard copy, whether it's electronic, more and more arbitrators are becoming comfortable with electronic bundles. In some ways, they're harder to prepare because getting them to for the hyperlinks to work and access to what may be a huge volume of documents can be quite a challenge. But they're becoming comfortable with that. So yes, if they do ask you for a bundle, mainly because they don't have an extra screen for themselves, then you'll need to supply it. That can be hugely difficult in lockdown situations, and you shouldn't hesitate to mention that it is difficult to them. They will potentially be quite understanding about that. But if they are looking for if they have their own bundle, they will want to be accessing it probably at the same time as the document is being shown to the witness and to the tribunal. And they often will want to do that for the same reasons they want a hard copy bundle, because they want to see, if you're referring to a document, what is shown in the paragraph before and the paragraph after. They'll want to have a look at that to make sure that the document is being presented as it sits in context. So give them a chance to come to the document as well as the witness, and make sure everyone is looking at the same document. That takes time, again, but that requires patience on your part and some sense of confidence, once again, that good cross-examination does take time, not only to prepare, but to present, and the tribunal will be patient as long as they can see that you're actually conducting an effective cross-examination and that it is actually proceeding. So those are the short points that I wish to make. There's a lot more to be said, and I'm sure Angeline can add to that.
Thank you very much, Angeline.
Yeah, so I was going to address when to stick to your script and when to deviate from it. I think one of the themes which comes out of both what Janet and I have said in particular is know exactly what it is that you want to get out of your cross-examination in terms of what you want on the page, because ultimately that's the answer to whether you stick with your script or not. It may well be that the witness gives you that answer that you need before you've even really got to the end of your questions. If that's the case, then you should stop. There's no need to pursue those questions any further. Equally, it sometimes is the case that you've asked your question, but they haven't answered in the way that you need. Maybe they've given you something a bit too general and you need to make it a bit more specific. Or they are they're deflecting and not giving the right answer, not giving a proper answer to the question that you're asking. So in those circumstances, you need to think about a different way of getting the answer out of the witness. And in those circumstances, you will not stick to your script. You'll think of different ways of asking the question. It may well be you've scripted some of that in advance, but quite often it's the case that that's the sort of thing that you need to be able to deal with on your feet. And what will help you deal with that on your feet is just really understanding the evidence and knowing what the witness will not be able to dispute, because you've got a document that shows it, or you know that it's accepted as being a core fact by the majority of the arbitration, or the tribunal is likely to accept it. That's what I was going to say about that. Alina, would you like me to address redirect?
Maybe we can move on in order to leave some time to speak about virtual hearings, a bit more time at the end. So, Jada?
Yes, so I was going to speak about the junior counsel's role during the hearing and during the cross-examination by leading counsel. which I believe is a very important question and very fresh for me. So it will obviously depend on many things. It will depend on how big the case is. It will depend on when, as a junior counsel, you became involved in the case. If you were involved since the beginning is not the same, because for very big cases, sometimes the team gets bigger to help on smaller things. But I think there is the substantial point of view and the practical one. From a substantial point of view, I think that junior associates have a real key role to play during the hearings, and that goes from knowing the cases, the case law, the exhibits, and the facts of the case very, very well. First of all, because they're going to be responsible for locating documents and make sure that the team is responsive and acting quickly. Well, that's maybe more of a practical issue, but you need to know the documents in order to be able to do that. And second of all, it's because they will have a real role when it comes to preparing rebuttal arguments and assisting the team of lead counsel. For instance, when you have the opposing party that is misrepresenting case law, when you know case law, you can immediately say to your to the leading counsel, actually, this is not true. Yes, but there was also this in this case law. So for the main cases, it's important to really know the facts of the case law and everything else. And again, when it's more the facts of the case, when the opposing party is referring to a document for a specific point, and you know that there is another document on the case that says the contrary or helps your case, as a junior, you should have that ready so that the leading team can actually rely on those documents. When it comes to maybe more cross-examination, this is also very important, because when you know all the documents that were signed by the witness or all the documents where the witness's name appears, you're able to react quickly when the witness doesn't give an appropriate answer. For example, it happens more often than not that the witness will just tell something that is contradicted by document on record, but the person doing the cross-examination will not immediately be aware of that. So you'll be there to find the document, show the document to the person who's doing the cross-examination so that the cross-examiner can adapt itself. Those are important. If you speak the language of the witness that is doing the cross-examination with an interpreter, I think you need to be even more careful to make sure that when it's your witness that speaks a language that the cross-examiner doesn't speak, make sure that there's not a bad translation so that your witness is not misled. And similarly, when you are examining a witness that speaks a language that the cross-examiner doesn't and you do, be careful so that your team of counsel is not later accused of misleading the counsel because of translation issues. For more a practical standard point of view, I would say that there's all the things of preparing the binders and so on, but I think everyone knows that very well. I think it's important to pay attention to the witness while your witness is being cross-examined, to make sure that your witness is being shown the right document, the right page, the right paragraph. Again, this is all just to make sure that your witness is not being misled. And similarly, when your team is conducting a cross-examination, be careful that the witness has the right documents so that you're not accused of misleading the witness later on. And there is a lot of practical things that as a junior you can be helpful on because everyone's going to be swamped and they're not going to have time to do it. So organizing the lunch, the cabs for the witnesses, for the client, all of that. I know that it will depend a lot on the country, because I know in Turkey these are very easy. But if you've had the pleasure of having a meeting in Paris, it's much more complicated. So be helpful any way that you can. Try to think about things even before they happen so that you can try to anticipate and talk with the relevant person. There's also another thing from experience that I've learned and I was confronted with, is that during breaks, breaks are not really breaks for the team of counsel. It's really the moment that they're thinking about specific things. And it's actually the moment where the client wants to go and talk to the team of counsel, want to know how it's going, if we're winning, if we're losing. And at that specific time, the lawyers really want to not be bothered so that they can concentrate on what they actually have to do. So you can always be there to the client to answer the client's questions from a practical point of view. And if the client starts asking you questions about how the case is going, you can give very vague answers without getting into the detail. But I think that's also an important role to have to support everyone that is there and preparing the case, basically. So that's pretty much what I wanted to say about the role of junior counsels, but I'm happy to answer any questions about this.
Thank you very much, Jada. Yelin, any brief comment on this topic before we move to the increasingly important topic of virtual hearings?
Well, actually, no. I mean, I'll just say two very short examples here, but I appreciate the time concern as well, so I'll be very brief. With respect to the role of the junior counsel, my examples are on. In an arbitration we were having, in one cross-examination, the witness was asked a question that had two steps, and the witness ended up confirming the second part of the question, but then the transcript ended up being reflected as if witness had confirmed every part of the question, and it was one of the junior counsels on our side that had realized the mistake, the flaw in the transcript, and it was going to be a very important thing if not realized at that time. And for instance, that was a correction, an immediate counsel by a junior counsel. So that's a good example of an important role of a junior counsel. And another example, again, a personal example we had was in one of the situations, the expert said ratification in Turkish, but he said it with another wording, and then it was translated like permission, which is given before something happens, whereas ratification happens after something happens, and it ended up being reflected in the transcript as permission. And again, that was spotted by a junior counsel right away and corrected on the transcript right away. Had it not been spotted like that, it was going to be it could have ended up causing a real trouble for us and for our position. But because the junior counsel immediately spotted it and we had a chance to correct it while everybody was present, we were able to correct it immediately. So those types of details are very important for the case, and these two examples are very good case examples where the junior counsels have really contributed a lot to the fate of the case. So I think these aspects are also things to be considered on the side of the junior counsels. I won't take longer because I appreciate that we're running out of the time with respect to this part.
Thank you very much, Yalin. And now we'll talk about virtual hearings and cross-examination in virtual hearings, which is increasingly important these days. So, Janet, would you like to start?
Yes, again, just a few very brief points, and they are, just as Cheda very helpfully said, logistics and practicalities are very much an important role that younger counsel can take on. You will not have to be ordering cabs, very likely, or dealing with hotel rooms, but you will want to be perhaps the primary point of contact with the hearing platform manager, the virtual hearing manager, whether it's, in Toronto we have arbitration place virtual, there's the International Arbitration Center or the IDRC or the SIAC or the HKIAC, whoever is the hearing platform provider. It will be very helpful for you to work with them to make sure everything is in order before the hearing. And that is a whole series of logistical points, everything from making sure that they have tested lines and tested the equipment of the arbitrators on down to the witnesses. So now when you come to the witness, you should know that the person doing the cross-examination will be in that person's own space. The witness will be in that witness's own space with no one around. That can be either very comforting or very intimidating for a witness. And it will be very helpful for you to speak with the witness, if it's your witness, about what the setting will be, about what the arrangements will be, about what they are allowed to have in the room with them, about what they might be asked in order to ensure that there is no one there coaching them, or no one on screen, or no one otherwise assisting them with their cross-examination, and otherwise helping them to understand what they will face when they are testifying in this circumstance. So prepared well, a witness should be able to deal well. In the cross-examination itself, again, you should know that that distance, although it may feel uncomfortable and unfamiliar to a counsel, is no barrier to effective cross-examination. It may mean that you need to leave a brief pause before the end of one person's speaking to the beginning of yours in order for the platform not to crash. But indeed, that's a valuable thing for you to do in any event. So what else can I say about it? It may be that you need to make sure the witness is in a place where the door is behind the witness, or it's otherwise clear that the witness is not being interfered with or assisted. But if, as you're cross-examining, things become heated, you can use the very same techniques that you would use in the hearing room to calm the person down. If the person's attention is wandering, again, you can use some very similar techniques to focus in on that witness, ensure that that witness sees that you're speaking to that witness, and take control of that person in that way. And the one last thing that I want to assure you of is, if the tribunal has the right equipment, which it is their responsibility to have, then you should be confident that the tribunal can see that witness as well or better than they might be seen in a regular hearing room. They can see every inflection, every reaction on the person's face. It's true that they can't read the feet, as people say mysteriously, the other body language that is somehow below the witness's examining table, but they can see that witness very clearly. And if you want that to be reflected in the transcript, you would do what you would do in an ordinary hearing. You would say, Ms. Terminator, you seem to be quite troubled by that question. Let me put it again. But you can do all the same things that you would do in a regular hearing to see that the transcript is a solid one. That's all from me.
Thank you very much, Janet. Angeline, any comments?
I'm just conscious that we're short on time, so I thought I might try and Janet has given a very helpful explanation of the differences between physical and virtual cross-examination. So I thought I would just pick up on some of the questions which we've had, some of which relate to the importance of body language in virtual hearings. I think that, as Janet says, everything can be achieved through a virtual hearing, and I don't think that it impedes the fairness of the process at all. But I think it is probably right that there is less subtle cues in terms of body language between counsel and the tribunal and the witness, even though they can be seen. And I think one has to be, the question which Janet in part touched upon is whether or not you will get those body language cues to the extent that you can pick up on them on the transcript. I think it may be difficult. You may be able to say, you seem troubled by that, but it's quite hard to say to witness, well, this seems to be irritating you, because that will irritate them further. So there has to be a fine balance, and it tends to be that actually arbitrators really remember the temperature. I know when I'm sitting, I remember the temperature of the cross-examination, the way in which the witness reacted. There was a question, which I think is an important question, about what do you do if you get an unexpected answer to a question? Should you just ignore the lead because it's not sure what you'll expect? I think there are two techniques for when a witness gives you an unexpected answer. The first is to deflect it, because actually you don't think that you can really tackle it. And you might say, well, I may come back to that later, or you may, if it's not really addressing the question that you ask, you go back to your original question. Or the other thing is that you just take it head on, because if you know the case file and they say something, it's very possible that you're able to react in the moment to challenge that by reference to a document or something else. So I hope that answers that. I don't want to say any more because I know that we're short of time.
Thank you very much, Angeline. Jada and Yalin.
Should I go very quickly on the question of dealing with an interpreter with virtual hearings, or should we?
I would say time constraints may be better if you have any comments on.
Yeah, I can just very quickly. I won't go into the detail, but I think that cross-examination with an interpreter is already challenging as it is. So you should be even more careful when it comes into when it's virtual hearings, because there's a chance that the interpreter misses a word or a phrase, or there are connection issues, that the flow of the cross-examination is interrupted by the fact that an interpreter is there. So I think the tools that are applicable in actual hearings are also applicable for virtual ones, which is the fact that you should choose a very good interpreter, maybe agree with the other party on some vocabulary when it's a very technical case, go very slowly, repeat your questions when it's needed, and don't get irritated by the fact that there are translation issues, because that's going to make you look bad and the witness more like a victim, I would say. So there are a lot. I can go more into detail, but I think I'm gonna stop here, and I'll be happy to answer questions if there are any.
We'll have questions and answers at the end after the mock exercise. So if anybody wants you or any of the other panelists to elaborate on any of the points, we are welcome questions. And Yalin, any last comments on the virtual hearing topic before we move to?
I prefer not to, because I see that everybody's probably eager to go on to the mock session, but just one very short comment. For some jurisdictions, including Turkey, there are certain discussions, because this is a newly emerging concept, the virtual hearing concept. There are certain discussions and arguments surrounding the virtual hearing concept, and this is just a heads up for various colleagues at different jurisdictions. In some jurisdictions, the way the virtual hearing takes place may end up giving rise to some public policy related arguments for the party who may be willing to rely on those arguments at a subsequent phase and so, but that's a very detailed and a long discussion, and it's more of an issue for less arbitration friendly jurisdictions probably, but this is just something to flag for the colleagues or participants here, and it's something to look in a case-specific way in different jurisdictions and so, but it may end up being an issue in various different jurisdictions. So this is just something I wanted to flag, but other than that, I think we can just move on to the mock session.
Thank you very much, Yalin, and thanks everyone. So now we'll move to the second part of our webinar, which is a mock exercise, a mock cross-examination demonstration. So our speakers will take the roles in a mock cross-examination. Angeline Wells will be the cross-examiner, Jada will be the witness, and Janet Walker and Yalin Akmenek will be the members of our arbitral tribunal. So I'll give this mock examination, will remind you, is based on the case that was distributed to you upon registration. So I'll give the floor to arbitral tribunal to start the process. Thank you.
Thank you very much, Alina. I have only two brief comments as we begin. And the first is that this is a demonstration. So you can expect that there are certain things that will be necessarily artificial. If we have a cross-examiner who is meant to demonstrate the good and the bad and the ugly, this is not necessarily reflective of the polished performance that someone of Ms. Welsh's caliber performs on a regular basis. But also, Ms. Chengisser is not often appearing as Ms. Martina Robot, and so you might expect her to take on a character that's slightly different from her own. But Mr. Akmenek and I will attempt to be sort of as true to life as we might be, interrupting only if it becomes very necessary, but also marking some teaching points that we hope will be picked up by the group afterwards. The second point that I want to make is very simply that normally in a matter such as this, we would have someone who's delightfully described in some situations as a document jockey, presenting for you, for everyone, the documents for the witness, for the tribunal, and for everyone else. We don't have that facility here, so you will not see on the screen in the same way that would happen in a regular hearing the documents, but they are the documents that you have received separately. So without further ado, Ms. Welsh, I believe it is your opportunity now to take the floor.
Thank you very much, Ms. Walker. Ms. Robot, my name is Angeline Welsh. I'm one of the lawyers representing the respondent Cyborg Tech in these arbitration proceedings. I'm going to ask you some questions today about your evidence. If anything is not clear, please ask me to clarify it. As timing is tight, I ask you to keep your answers as short as possible. Do you understand?
Yes, I do.
Very good. I'm going to start by asking you some background questions. You established Tech as a startup and developed it into one of Ruritania's leading tech companies in a period of 5 years, correct?
15 years, yes.
15 years. I stand corrected, 15 years. So is it fair to say that you're experienced through those 15 years at running a company?
I mean, depends on what type of company, but I am experienced in running my own company, yes.
You're experienced in running Tech, that's correct, isn't it?
Yes.
And given this experience, you are aware, aren't you, that the board of a company is responsible for setting the strategic direction of that company?
Yes, that's usually the role assigned to it.
Very good. And you would agree that the managing director of a company acts subject to the supervision of the board?
Yes, yes.
Very good. Okay, well, let me move now to talk about the background of the relationship between Tech and Cyborg Tech. So Cyborg Tech approached you with a view to acquiring Tech, and at that time you were pleased about that approach, weren't you?
I was pleased, yes.
And you were pleased, weren't you, because Cyborg Tech is a leading multinational defence, security and aerospace company, isn't it?
Yes, so it is a big multinational defense, security and aerospace company, and that was interesting for my firm as we were growing and we were very successful at the time.
Very good, but it was considerably larger than Tech, isn't it?
Yes, because Tech is my company. It's mid-size and it's privately owned.
It was your company, wasn't it?
Yes.
Yes, it's no longer your company because it was sold to Cyborg Tech. That's right, isn't it?
Yes.
And at least as far as you were concerned, the acquisition presented a significant opportunity to allow Tech to grow internationally by taking advantage of Cyborg Tech's presence in the particular markets.
Yes, that was how I've seen it. Yes.
Very good. Well, Ms. Robert, I want to take you to a document now. Can you go to Exhibit 10, which you will find on page 26 of your bundle? And
could you repeat that, please?
It's Exhibit 10, and you'll find, well, the start of the document you'll find on page 24. So you may want to go there first, and if the tribunal could nod when they've got the document in hand. Very good. So Ms. Robot, this is the PowerPoint presentation given by Cyborg Tech when they presented to you their ideas for acquiring your company and the benefits it would bring. That's right, isn't it?
It is.
And the page that I'm particularly interested in is page 26. So if you were able to turn the page and look at the slides on that page. Do you have that?
Yes, I do.
Very good. And you see on the first slide...
I'm just going to that. Could you just pause?
Yes, I do apologise, Miss Walker. I'll wait until you're there.
We have it now.
Thank you very much. I'm interested, Ms. Robot, in particular on the first slide, which appears on that page. The second bullet point on that, it's fair to say, isn't it, that prior to entry into the SPA, Cyborg Tech identified 3 specific markets where there was a specific interest in seeking to develop. That was North America, Africa and China, wasn't it?
Here it is, here that's what is stated, but you do know that we have an agreement that is more general than this one.
Well, I'm not asking you questions about your agreement at this stage, Ms. Robot. What I'm asking you is what was presented to you by Cyborg Tech. So what was presented to you by Cyborg Tech was that they thought that the opportunity for development were the 3 markets identified on that slide. That's correct, isn't it?
Yeah, that's what is written here, yes.
Yes. And it was on the basis of accessing these markets that an expected global growth 40% return was expected. We see that for the second slide. That's right, isn't it?
Yes.
And prior to entry into the SPA, Australia was not identified as a target market in order to achieve that 40% growth, was it?
If again, we're just talking about this document, and this document, it's not.
It's not mentioned in the SPA either, is it, specifically?
So in the SPA, maybe we can, I mean, it's not in the SPA Australia, but it is stated in the SPA that the company says that it's including North America, Africa, and China. So there's no limitation in the SPA. So I wouldn't say that Australia is not included.
Ms. Rowett, the question that I asked you was that Australia was not identified as a target market in order to achieve that 40% growth prior to entry into the SPA. Could you answer that question?
But what are you directing me to? If it's the SPA, for me, the SPA does not exclude Australia because it doesn't limit the business plan.
Well, let's go to the SPA because it may mean I may need to clarify my question. If you go to page 11 of the exhibit, you'll find Article 5, which is what I believe you're referring to. Do you have that?
Yes, I do.
Does the tribunal have that document?
Yes, we do. Thank you.
Very good. So I believe, Ms. Robot, that you're referring to Article 5.1a, which is setting the company's goals and targets within 2 years of closing. Is that correct?
Exactly.
Yes. And my point to you, I appreciate the point that you want to make about the interpretation of that contract. But the point that I'm making to you is that prior to entry into the SPA, the Australian market was not identified as a target market. That's the point I'm making. Would you agree with that?
I wouldn't, because for me, you are interpreting the clause. We can say that it's not listed in the including side of the article, but it's not excluded because it says to expand the company's business in other markets, including.
Very good. We agree, I think, that Australia is not identified in the SPA because that's what you've just said. I'm not asking you...
That I would agree with.
Yes, very good. I'm not asking you about what was excluded. I'm asking you if you can point to me to any documents which show that Australia was identified as a target market prior to entry into the SPA.
No, that I don't have it for you. I just know that I was generally asked to develop the business, and that's exactly what I tried to do.
Very good. But to go back to my question is, was Australia identified as a target market prior to entry into the SPA? It's a simple yes or no question.
No, it was not.
Very good. So, at the time that the SPA was entered into, the 40% growth was not identified as being dependent on growing the Australian market, was it?
I mean, I feel like we come back to the same questions. For me, it's just a matter of how the wording was done and what they actually expected from me. They wanted growing markets, and I found a growing market, which was Australia. So if you are asking again whether Australia is specifically identified, maybe it's not, but it was not excluded.
No, let me break the questions down. We just established that Cyborg Tech identified the markets of North America, Africa, and China as being the basis for an expected return of 40%. You agree with that?
Yes.
You also agreed with me that Australia was not identified as a target market prior to entry into the SPA. Correct?
Yes.
So I put it to you that the 40% growth which the parties expected at the time of entering into the SPA was not dependent on developing the Australian market. You would agree with that?
No, not that 40%, maybe not, no.
Okay. Would you agree with me that a decision to expand a new target market is an important strategic decision?
It is.
Very good. Okay, let's move now to talk about the terms of the SPA. We've just looked at Article 5. You negotiated the SPA, didn't you?
I did negotiate it, yes.
Yeah, and you're aware that the laws of Ruritania impose limitations on the transfer of shares, aren't you?
You're asking me questions, but I'm not a lawyer. These are legal questions.
Okay, fair enough. I'll take that question back. It was agreed following the acquisition that you would continue on as Managing Director of Tech and Tech, correct?
Yes, and for good reason, because I knew the company, I knew how it operated. I was a very successful businesswoman at the time. I had many awards. So it was...
I'm sorry, I'm going to have to stop you there. We've got a very short amount of time and we need to get through my questions.
Okay.
You were required under the SPA to perform your role as Managing Director as a prudent business manager acting with due care, weren't you?
Yes.
Very good. And we looked at Article 5 earlier. I don't need to take you back to that unless you want to, but that also provides that part of the goals of the company was to integrate and manage the company Tech and Tech in compliance with the buyer being Cyborg Tech's business development strategy and security policies. That's correct, isn't it?
That's not in Article 5, is it?
Let's go back to it. If you go to page 11, which is the start of that article.
Yes.
And then you turn over to page 12.
Yes.
It's subclause E, which I've just read out to you. Do you see that now?
Yes, I do.
So you agree with me that that was one of the goals which the
Yes.
buyer and seller were required to
Yes,
agree.
it was.
Very good. And ultimately, acting as Managing Director, you were required to follow the instructions of the Board of Directors, weren't you?
Yes. I mean, I was working under the board supervision like managing directors are.
Yes, very good. And in addition, the Board of Directors are entitled to reach their own view and strategy for the business, aren't they?
Yes.
And if they reached a view that you disagreed upon, then you would still be obliged to comply with that decision of the board, wouldn't you?
I mean, yes, I wouldn't do something that is not authorized by the board, but the whole question is why the board did not authorize something that they should have.
Well, we'll come back to that. The Board of Directors was controlled by Cyborg Tech, wasn't it?
What do you mean controlled?
Well, they had the majority position under the SPA, didn't they?
They did. They had 3 directors and we had 2.
Very good. Okay. Let's talk about what happened after the SPA closed on the 1st of February 2016. So following entry into the SPA, you disagreed with the board as to the business opportunities which ought to be explored by Tech and Tech, didn't you?
I mean, this is a way of seeing it. It's just that for me, I had a vision and they put me in that company because I had a certain vision. And I found at that time a market that was very good and growing. And I brought that market to them.
Well, Ms. Robert, if we go back to the question that I asked you, I asked whether you disagreed with the business opportunities which you thought ought to be explored by Tech and Tech.
Yes, I did. I didn't understand. I honestly didn't understand why they were so close.
And in particular, you considered that a tender with the Australian government should have been pursued, didn't you?
Exactly, yes.
Yeah, right. And so you organised a meeting with the Australian Defence Agency and others for the 3rd of June.
Yes, I did.
Okay, and prior to that meeting...
But wait, excuse me, what document are you referring to? Because...
I didn't refer you to a document, Ms. Robot.
Okay.
I suggest you listen to my questions. Prior to attending that meeting, you didn't seek to consult the board as to whether this opportunity should be pursued, did you?
I don't remember. I don't remember. Perhaps there has been discussions with some of the directors beforehand. I don't remember.
Let's go to page 18 of the bundle. Do you have that document?
Yes, I do.
Does the tribunal have that document?
Yes, we do.
Well, this is the minutes and resolution of the board meeting on the 19th of June 2017. This was the first time that the board considered the Australian opportunity, wasn't it, after you'd had that 3rd of June meeting?
I believe so.
And there are no other board minutes where this issue is raised, are there?
Not as far as I can recall.
So the board hadn't considered this in a meeting prior to the 3rd of June, had it?
3rd of June, 19th of June.
The meeting that you had with the Australian Defence agencies and others was the 3rd of June.
I mean, I don't remember. How was it the 3rd of June?
Well, we can go through it, and counsel on the other side can correct that date if it's subsequently shown to be wrong. But if you just accept for me for the moment that your meeting with the Australian Defence Agency and others was the 3rd of June. The point I'm making to you is this is the only board minute which record the board having considered the Australian opportunity.
Yes.
Right. So there's no board meeting prior to the 3rd of June, is there? This one being after the 3rd of June.
Yes.
Very good. And we can see that you're present at this meeting together with all the other directors.
Yes, I was.
And we see that at the paragraph 3 under the list of attendees, that the board rejected the proposal to expand into the Australian market on the basis that such a proposal, such a project would require substantial time and involvement, and they did not consider it a sufficiently strategic market.
Yes, that's what happened.
Yeah, and that was a decision that the board was entitled to reach, wasn't it?
Entitled, I mean, yes, I guess.
And it's also fair to say, isn't it, that the Australia opportunity, the Australian market, was your primary focus in terms of expanding tech and tech's business, wasn't it?
I mean, I'm a business person, so I see an opportunity, I go for it, I make my due diligence. I don't just function geographically, I function with opportunities.
That's not the question I asked. The question that I asked was that it was a primary focus during your term of managing director, the Australia opportunity.
Because the circumstances allowed it to be so at that time.
Right, but you would say that was your primary focus. You'd agree with that?
Yes.
Disagreeing on that point.
Yes.
Ismail, if I may, can I ask you how much more you're planning to take for the purposes of the time management of the tribunal?
I have, I would say, around 5 more minutes, but I'm content to rest there if the tribunal consider that we've exceeded our time.
Thank you very much, Ms. Welsh, and thank you, Ms. Robot. That was very, very helpful cross-examination. So if we can perhaps, Mr. Ahmed and I can begin to make just a few observations about what we heard. It was indeed interesting and I think quite helpful. You could see the first point that I would like to make is you could see Angeline listening very carefully to the answers that she got. Some of them close, but not what she wanted. And to take the time to take the witness back, without irritation or frustration or anger, but just take the witness very carefully back to put the question again in so that the witness can be aware that that hasn't been answered, but also to be very clear about what's being asked can be helpful. There is always a judgment call to be made. It may be that what you've got is enough, and the time is passing and the person wants to blather on with an explanation about why that was. As long as you can do as Angeline did, so would you say that this is the case, then you may well get the answer that you got, which is yes, that is true. And then they'll be prepared to move on because they will think that their explanation is on the record. So that's the first point. Yaline, do you want to jump in with a point?
Not yet. I'll jump in a few moments, but I think we can move on with this point.
Okay, and another point is about legal issues. So there was a point asked about Ruritanian law imposing limitations on the transfer of shares. Well, if the knowledge of that is a relevant factual point, just the same as knowing whether it was discussed with the board before a certain period of time or not, if that's a relevant point in the facts, you can ask the witness, were you aware? They won't be able to say whether that's correct or not, but they will be able to say, yes, that provision was in the SBA, or yes, we were very concerned about that limitation. If that's a relevant factual point, then yes, the fact witness can be asked that question. But it's absolutely true that the fact witness should not be asked to give an opinion on the law. That's for counsel to observe. Now, can I think of other things? Yes, we could see that although Cheda was being, I thought, generally quite cooperative, there were times when a nerve was touched and immediately she wanted to sort of go off in a different direction, tell you what kind of person she was, why she was acting in a way that was entirely appropriate, why those other people were doing bad things that were inappropriate. And sometimes that's in the way the question is asked, but sometimes that's just the witness. Sometimes the witness never wants to be quoted on anything, never wants to be pointed to a document that they've signed or an email that they've sent. And you just have to be mindful of that. But again, keep them focused, get the answers that you want.
And maybe, if I may, Janet, going back to what you said a minute ago about asking legal questions, and so, we're always saying, always ask closed questions, don't ask open questions, and so. And when you end up asking legal questions or asking questions where you ask the witness to opine on something, you give the witness a chance to give a very open-ended response, and you kind of risk losing control when you're interviewing the witness. So that's another reason why it's probably best to avoid those types of questions.
Indeed, it is. Sometimes there's nothing you can do to keep the witness on track. Very recently, I had a witness that went on. I didn't have the witness. Fortunately, I was just observing as a member of the tribunal. But the witness took a day and a half for a cross-examination that should probably have been 2 hours. And the counsel was enormously patient, would take the witness to a document, an email, and say, do you have this email, Mr. So-and-so? Can you see that it says on line such and such this? And he would say yes. And then she'd say, so is it fair to say that? And she would recite what was in the email. And then that would begin denials and obfuscation. And it went on for ages and ages. But at least it was very clear to the tribunal that regardless of what the witness had responded, those words were actually said by that witness in an email. So don't be discouraged with a difficult witness. You may be making headway nonetheless. And so even if you don't get a perfect answer, it may be quite sufficient. I did also want to make one further point. There's the I don't remember. What do you do with that? At one point, Cheda said, I don't remember. And you wondered, well, does she not want to remember? Or does she genuinely not remember? And maybe it doesn't matter. If Angeline was great on this, she went right back and said, okay, well, let me explain why that is so. on the documents, and having explained it, then immediately Cheda sort of had to accept that that was the case. So the I don't remember can be a slightly more complex scenario, but in the end it probably comes to the same thing.
And on that I don't remember thing, Janet, I think if there is something in the bundles, in the testimonies also, where the counsel can direct the tribunal to at that point, it's a good idea to do that. But if there is no specific thing that the counsel can refer to at that point, and if the counsel insists on, don't you remember, are you sure you don't remember this? And so it's usually not a good idea, because it never ends up in the right way when you end up getting into that kind of an argument with the witness.
I'm sure there are many questions from the audience, and I don't want to cut off that opportunity, or comments actually from you, Cheda and Angeline, about things that you sort of noticed in the course of the cross-examination.
There was a bit of, I tried to speak over the top of Cheda at one point. To be a bit,
wasn't that bad.
It wasn't as bad as it could have been. I'm finding it difficult to do that. The other thing that I thought is that I did in my script have a couple of open questions, which ultimately I didn't ask because Cheda had sort of got there before me, so she'd given the answer that I was going to, because she was doing a good job on answering some of the other questions to make my life difficult. So, but I mean, I think we had a question earlier about what is the difference between open and closed. Closed, the danger with open is that you lose complete control of your witness because they'll just go on and make their case. And you can see most of my questions, very closed questions, and that keeps control. The one thing I would say is there will be, you shouldn't be too strict about that rule, because there may be one or two times where you don't care what the answer is. So you might just give an open question, but you know, you really should avoid them as much as possible.
Maybe one point I can add is, you know, this is actually an example of a virtual hearing, and in a physical hearing, it's easier to follow the mimics and the requests of the tribunal in an easier way. But in a virtual hearing, for instance, you don't know if the tribunal is really has reached to the specific page of the bundle which you're referring to, or whether the tribunal has managed to see the page that you're referring to. In a physical hearing, when you're face-to-face with the tribunal, it's easier to see that because you see the hands, and then you see their folders, and you see whether they're still turning around in pages and so. But in a virtual hearing, this is harder to detect. So it's a very difficult thing, one of the difficult things of a virtual hearing. But sometimes, and I think, Angelina, you did it perfectly, it may be good to check with the tribunal when you're referring to an important document, whether the tribunal has actually found that document, because it's sometimes difficult to see it on the screen. So it may be worth checking it in a bit more during a virtual hearing with the tribunal.
We got a question. Oh, sorry.
Just one thing that I wanted to say as playing the role of the unbearable witness is basically, I think when you as a witness try not to cooperate too much, it does look irritating, and it is irritating for the tribunal, I think, to have a witness that is trying to do whatever they can to not avoid the question. And I think I try to also show what happens when witnesses, what I was talking about, the fact that some witnesses are sometimes too prepared and they're trying to basically play the role of the counsel. For example, when Angeline was asking me questions that were yes or no questions, I was going more at a detail and going to the SPA, even though we were not there yet, and at the wording of the SPA. And I think that shows that maybe sometimes the witness is maybe a bit too prepared and is not answering and cooperating and not answering properly some of the questions. And obviously, I didn't have the emotions of Mrs. Robot, but in real life, usually the witnesses have a lot of emotions, especially if you're cross-examining the main witness. So I did try to show that sometimes they will, whatever you do, they will go back into that emotion, and they will try to make sure that the tribunal knows what they went through and how emotional this thing was for them. And I think at that moment, it's important for the cross-examiner not to get into that. And when you're cutting it, just make it in a very polite way so that you respect the witness's emotions, but that's not what it is about.
Yeah.
I would like to thank you all. I'm sorry, go ahead.
No, fine. If we're up against time, I was just going to answer a question, but it's fine.
No, it's a go ahead. I'm sorry for interrupting.
No, I was just going to say that there was one question about what to do when a witness keeps on giving irrelevant information and how does one recover from asking an open-ended question. So on irrelevant information, I think you can, if it's irrelevant, it doesn't really go to anything, you can be patient to begin with a bit, but then you need to start signalling quite clearly that they are wasting your time. Not by necessarily being rude to them. You can be very patient with them. You can say to them, look, it's really important here that you answer my questions because, and you focus on the question I'm asking you, because if I don't get an answer to it, I'll have to ask it again and I don't have enough time to answer that. And eventually, if they persist, you can almost appeal to the tribunal and say, you know, essentially I'm having a difficulty because they're not answering a question. They may benefit from a direction from the chairman to answer my question. How to recover when asking an open-ended question, it's sort of a judgment call, I think, because if you've asked the question, you can't really retract it very easily, and you oftentimes just have to let them get to the end of the answer and then start again. Sometimes, if you've done it a bit and you're up against time, you might be able to gently intervene and cut them off a little bit, but it will really depend on the patience of the tribunal, because some tribunals could be quite irritated by that. But I mean, I think ultimately you need to sort of just go back to your script, or if there's anything useful in the open question, then pick up on that and get back into your script.
And from the perspective of the arbitrators, it's absolutely right. There's a bit of a judgment call. You don't want to dive in and say, now, you know, Ms. Robot, what we really want to hear about is this, because you want to let the cross-examiner get what she wants out of the cross-examination. You don't want to take it over. But at the same time, there will come a time when you see that the witness is just willfully wasting everyone's time. And gently to sort of step in and say, now, you know, it's very important for you to focus on the question and answer just the question, can sometimes actually be quite effective, you know, notwithstanding what the cross-examiner is able to do. And, you know, as a cross-examiner, you should be quite aware that the tribunal knows that. Sometimes you can only get 90% of what you want, and you just have to move on. Remain calm. The tribunal has probably appreciated that that's the best you're going to get and why the witness is obfuscating and what the answer is good for.
Thank you. We are now going to proceed with the last part of our cross-examination webinar, namely the Q&A session. And in that regard, I have some good and some bad news. The good news is that we are in awe with the number of questions that we received through your registration forms and through the Q&A form right now. This level of interaction was exactly what we had hoped for. And also part of the good news is that your questions submitted through your registration forms have been shared with the panelists ahead of this webinar, and they have engaged with your questions through the Q&A forms up until this moment. The bad news is we are running out of time, so I'm going to try to make the best of it and limit the number of questions to the most pressing issues, and be a cross-examiner myself to keep them as close as possible. So please feel free to answer the questions, the ones that you would like to answer, and we would really appreciate your insight on these questions that have been asked by our participants. The first one will be, there has been an issue about open questions, about how they can go wrong, but of course they can also be perfect at a given moment. They can be the right touch at one point of the cross-examination. How do you determine when open questions are more effective?
Did you want to say? I mean, I think I've partly addressed this already in my thoughts. I think the open questions are great if you don't really care what the answer is. You know, describe what you did in that role. Like, you may not care what they did in that role, but it just gets them talking and sort of warms them up a bit, makes you look like you're not too afraid about what the witness will say. So there's sometimes reasons for doing it. But most of the time, they're probably to be avoided because it will allow the witness to run away with you.
And as Angelina said, sometimes controlling the witness doesn't mean intimidating the witness. It means actually putting them at ease. The charm offensive can sometimes allow them to feel a little bit more comfortable, and they'll be a bit off their guard.
I'm going to move on to the next question. Thank you very much for your answers. We saw during the mock session what to do and what not to do when you're faced with a challenging or, let's say, a difficult witness. But what about if a witness gives an unexpected answer, not necessarily for being difficult, but it's just not something that you had accounted for when you are preparing for the hearing? Should you stick to your line of questioning, or should you follow the witness's lead, even if you don't know what the answer will be?
Well, on that, I think one of the important things is, if it's a very important subject, if it's a very important question, it may be better not to ask a question if you are uncertain about the response that you will get, or if you are going to get a response that will really surprise you and you're not going to be able to rebut it in some way. Then if it's an important subject, then it's better not to, in my view, not to ask the question if you are not sure about the answer that you will get, or if you'll get a surprise answer, if you'll not be able to rebut the question. That's one comment on my end. I think, Janet, you were going to say something as well.
I'd be happier. I saw a question that I was looking at on the chat.
Okay, sorry. I thought you were going to say something. That's
no,
why.
About experts or something. There was a question.
I was just going to add to that exactly that you usually don't ask questions that you don't know the answer to, and if the witness gives a very surprising answer and you know that it's contradicted by other documents, you have to be at that moment very reactive and be able to, without cutting the flow, point to those documents. And that's why the junior associate's role is also very important, to help bring those documents that were not initially in the plan but that needs to be treated, to put the witness back on track.
Thank you very much for those answers, and I'm going to follow Janet's lead about one question at the Q&A forum. That will be, when you are dealing with cross-examination of expert witnesses, most of the time the counsel seems to be attacking the expert's credibility and not the material underpinning the expert's opinion. What would you think about this?
I'd just like to say generally about credibility questions. There's one view that as soon as you can trip a witness up on a point, no matter how small, you can immediately sort of lunge for the jugular and try to get the witness's entire testimony removed from the record. It doesn't quite happen like that. People forget things, they make slips, they misstate, and sometimes they exaggerate. It is a long way from saying that the tribunal will be prepared to reject that witness's evidence entirely. And we saw that with the evidence about when did the board first come to know this. Remain calm. You want to get what you want to get on the evidence. And only very rarely is a direct challenge to credibility very helpful. The tribunal will often be mindful of the fact that some part of a witness's testimony, no matter how dodgy a character that witness might be, is of value, and that often what you get are not differences of fact, but differences of interpretation as to what they meant in the business relationship. And those are things that the tribunal will want to work out later. Those are not the basis for rejecting a witness as entirely unhelpful and untruthful. And it's often not helpful to try to take that big an attack.
Thank you very much. The final question is the one that I'm actually most interested in. What is the worst experience you had as a cross-examiner in cross-examination, and what would the one tip be that you would give to people who would do their first cross-examinations based on that experience?
Gosh, that's a good question. I've had, I think some of my worst experiences actually have been when my witness hasn't held up against the cross-examiner of someone else, but conducting my own cross-examination. I think one of the tricky things that junior counsel has to deal with is that normally the witnesses that you get to begin with are the more inconsequential witnesses. So they have quite short witness statements. It may be that nobody really minds very much what they say or not, and that so they sort of given you to cut the teeth on. But the challenge, I think, is that what do you really get from them, which really assists the case, and trying to make sure that you ask the right questions. And I think often in those situations, less is more. So I think the tip is to, recognise that there may be only 1 or 2 points that you can get from the witness, but don't feel that you need to spend a long time with them, getting them to read through documents or something else just to justify the cross-examination. If you've only got 1 or 2 points, just go for it. And that will be a short cross-examination, still a good one.
Thank you. Anyone else who wants to add to that?
I can just add with an example. This wasn't something that happened to me, but this is something I watched. And the cross-examiner, the counsel, asked the witness a specific question. Said they were in an argument and so, and there was lots of tension and so, and then the counsel said, "So you're saying this had no impact on your purchase decision? Is that correct?" Type of a thing was asked to the witness, and the witness said, "Yes, I am saying that." And then the witness said, "If you also look into page blah 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 of your main witness's statement, your witness is saying the same thing as well." And then everyone froze, and then the counsel that asked this question was so surprised that, "Oh, is he saying that he inadvertently asked that as well?" And actually their own witness was saying exactly the same thing. It wasn't a very important point, but the counsel asking the questions just ended up losing control and asked a question which was contradicted by their own witness. So that was an embarrassing situation where the witness ended up winning the fight in an unusual way. So that's an example I can share.
Thank you all very much for your contribution. I would like to first of all thank all our panelists, Angeline Mouse, Janet Walker, Ceyda Cengizer, and Yalın Akmenek for a very informative workshop. It was a fantastic opportunity for all of us to hear tips from the renowned arbitration practitioners and to see these principles in action through a mock trial. Thank you very much. I would also like to thank the steering committee, Panos Kalkias and Alina Papanastasiou from Young ISTAC, Selda Taşürek Köksal, Esra Öğüt Öhri, and Can Işıktaş from Young ISTAC. It has been an utmost pleasure to have been among the organizers of this event with you. Originally, we were aiming to have a physical and all-day workshop on cross-examination to be held in Istanbul. And once the COVID-19 pandemic no longer poses a threat to physical gatherings, we as Young ISTAC in partnership with Young ISTAC aim to realize this physical all-day workshop. As a former participant in a previous version, I truly look forward to this prospective event in Istanbul and hope that we will have a chance to meet some of you there. We, as Young ISTAC, are a forum of young professionals of the arbitration and mediation community in Turkey. Established in 2016, we are organized under numerous commissions, and physically and virtually we host and organize seminars, conferences, moot competitions. We contribute to the theory and practice of dispute resolution through publications and engage in partnerships and cooperations with other young arbitration organizations. This event, this evening, was one of the most successful ones, and we are grateful to be taking part of it. We are a group exceeding 3,500 highly motivated and active young lawyers. We aim to promote alternative dispute resolution under ISTAC, an innovative, modern, and efficient dispute resolution center. The Young ISTAC membership is open to all under 40 practitioners of the arbitration community without any subscription fee. Please feel free to visit our website for further information and registration. Thank you all for joining us in this fantastic webinar, and I wish you a fine evening.
Thank you for having us, Adina and Leyla.
Thank you.
Thank you.
Thank you very much. Have a nice evening.
Have a nice evening.